And we're off. Welcome, everybody. Estate planning attorney Paul Rabelais here. I have another action-packed live stream. You never realize there's so many different topics to estate planning until you start making a list of different topics that you can present to people. So a lot here. And in this live stream, it's all about when someone who set up or someone with a living trust dies, what happens next? So, man, today flew by. I had 4 different meetings, one with a couple who wanted to just eliminate the probate for their 2 children, another single person who had just retired and didn't have children. We were setting things up so that when he passed away, because he didn't have a spouse or children, things would go to his siblings. Some of his siblings had predeceased, so things will go to predeceased siblings' children. Another single person wanting to set things up for their children. Dealt with actually a trust administration today. So there's a person who had a trust and passed away, and now the successor co-trustees are dealing with various issues relating to the distribution of trust assets, which really is the topic for this live stream. And just got off a Zoom call with another couple who owns a business, and one of their children is in the business. So they want to set things up so that that child can continue owning and running the business after the parents pass away, but all the children are treated equally. So just a day in the life of being an estate planning attorney. Kind of, oh, by the way, if you have an interest in just having a discussion, perhaps even with me, about what your estate plan design might look like, you can click a link in the description, request a time. If all works out, we'll send you a link to my calendar. We'll be off and running. Okay, so when someone with a living trust dies, what happens next? I really want to break this down into 3 parts. One, what's just the typical scenario of a living trust settlor dying? We're going to run through an example. Just tried to create an example that gives you all the high points. And then second, I want to discuss many of the unique issues when you have a married couple and the first spouse dies, and what are some of those unique estate settlement issues. And then we'll discuss some other issues, and we'll be off and running. So I already see some good stuff in the chat. Always want to say hi to Larry. I don't see Ann yet, but usually when I say hello to Larry, Ann chimes in from Tennessee as well. So welcome everybody out there. Larry, good to see you as always. All right, let's jump in. Let's just jump right in by talking about the typical trust settlement scenario. And really, this is important because there's so much out there on YouTube, other places, websites, about how important it is to create your trust, set up your trust, have your pour over will, your powers of attorney, in your trust, you'll name your beneficiaries, you'll name your successor trustees, you'll fund your trust. So much written and so much said about setting up a trust the right way. Not nearly as much out there on, okay, well, if somebody set up a trust, they're going to die eventually, and their trust has to be settled or administered. And so that's what we want to bring some attention to this evening, is what are some of the issues involved in that trust settlement or that trust administration. Somebody set up perhaps a revocable living trust and they died. What happens next? Okay, so let's jump in. Let's just talk about a typical scenario. We'll first talk about an unmarried person who set up a trust and then they die. And then we'll change the facts and get to a married couple. Either they set up a joint trust together or they set up trusts separately. We'll talk about the administration issues that are involved when a married person with a trust passes away. So there are many different kinds of trusts, and but really what we're talking about here is kind of the most common kind. Somebody set up a trust as the vehicle whereby they'll pass along their heirs to their closest loved ones, and they'll designate people to oversee all of that when they die. That kind of will replacement revocable living trust, almost always set up for the purpose of avoiding the court and attorney involved probate that happens when things are titled in your name when you pass away, whether you have a will or not. So the idea, set up your trust, transfer your assets to your trust. Things in a trust don't go through probate. You pass away, you've got a successor trustee named, who generally it's their job to distribute the trust assets to the beneficiaries. But there's more than that. That's what we're going to talk about. So our example is, and I'm going to go back to old Fred Flintstone. And let's say Fred set up a trust. Let's say he's not married. I know in the show he had a wife, Wilma. We'll get to that in a minute. But let's just say for now, Fred is not married, and Fred just has the the typical assets that people have, in America, especially if they've accumulated some things. So in Fred's trust, he has his home is titled in his trust. His bank accounts could be checking accounts, could also be a savings account. He's certainly going to have a checking account. Also going to have a savings account, may even have some CDs in the trust, likely to have some brokerage accounts that are not retirement accounts, but he's got some after-tax, savings that he invested in. And so he has some brokerage accounts there in the trust, his vehicles in his trust. Maybe he has some stock in particular companies that are held in a computer share account. Maybe, let's say Fred owned a business, or maybe didn't own a business, but he owned an interest in an LLC, which could have been a business, could have been a rental property, could have been any number of things but Fred did own part of an LLC. And let's say even Fred owned a condo or some rental property. Okay. So Fred has died, and let's say his friend Barney is now the trustee. So in Fred's living trust, Fred named himself as the initial trustee, but Fred's trust said that when Fred died, then Barney becomes the trustee. And let's say Fred has 2 children at the time. Fred's 2 children are the beneficiaries to receive the trust assets when Fred dies. Okay. So now when Fred dies, it's really Barney's job as the successor trustee to dig in and get done what needs to be done. Let's talk about what needs to be done. I'd say the first thing Barney should do is he should really, and maybe there's 3 or 4 first things, but the first thing I want to point out that sometimes people make mistakes on is they mistakenly think they know what Fred's trust says, but they really don't. And so and if you need to get some legal help to do it, get yourself some legal help. If the trust is written where, hey, you got it, Barney's got it, he understands, great. So the first few things that I'd look for in Fred's trust is, number one, show me the successor trustee. Who's the trustee? Under what circumstances? What does it take for someone to be a trustee? Are there co-trustees? If there are co-trustees, can they act individually? Do they have to act together? If there's 3 or more co-trustees, can a majority act? Can one act? Do they all have to act jointly? So I'm going to look at those trustee provisions to make sure that as we move forward, the right people are acting in the right capacity. The other really important and obvious thing that we're going to look for in Fred's trust is, who are the beneficiaries? Who's entitled to receive the assets in the Fred trust when Fred passes away? So does it say it goes to descendants per stirpes, which means it goes to Fred's children, but if children predeceased Fred, then the child's share goes to the child's children. Does Fred leave any specific bequest? Does Fred say, I leave $10,000 to this person, $25,000 to my church, and the rest of my estate to go this way? So we want to look closely at the beneficiary provisions to really understand that. I was involved yesterday in a trust that was over 150 pages long, and there were references to beneficiaries all over the place. And it took us a while to really, because the person had died, and it took us a while to figure out, to sort it all out, who the actual beneficiaries were and what were everybody's rights and responsibilities. So that's one of the first things I'd do, is I'd made sure I understood the trust instrument. Also need to mention, was talking with an individual 2 days ago. Father had passed away. Father had a trust. During father's lifetime, father had made a durable power of attorney and named son as his agent. So I'm talking on a Zoom call with the son. My father died. And, but don't worry, Paul, I have power of attorney for my father. And I was like, well, maybe I should worry a little bit, because that power of attorney has no effect anymore. So if Fred had created a power of attorney while Fred was alive, as soon as Fred died, that power of attorney is no longer effective. And then since Fred had a trust, The successor trustee, who was named in Fred's trust, now takes over from the moment Fred passes away moving forward. So you got to look at all that stuff. So you need to determine what next. You need to determine what the assets are. Where are all the bank accounts? Where are the brokerage accounts? What does he hold in computer share? What LLCs does he own? That can get really, really complicated for a successor trustee. One of the things we do in our firm, we get all of our clients who create their wills, create their trusts. We give them an online vault account so that they can store all of the assets, all of the information on all of the assets that they own. We get access to it. They can make other family members users to their vault account if they want to. All their estate planning legal documents, the wills, the trust, the powers of attorney, once they're signed, they all get uploaded to the client's vault account. And so there's one secure place online so that when Fred dies, for example, the successor trustee, Barney, just needs to go online. Everything that Barney would need is right there at Barney's fingertips. So sometimes just figuring out what somebody owned when they died, or what was in their trust, or what was in their name when they died, sometimes that can take months. Sometimes you're like, and a lot of people have said, Paul, I'm the trustee of my father's trust, and I know he had a $4 million account, or I know he had stock worth $3 million, or I know he had $2 million, of mutual funds, but I just can't find the information. And most of the time it was like, so when did your dad tell you, or what information leads you to believe that he had a $4 million account? Well, 25 years ago, he told me he had a big account somewhere. So some of those assumptions that people make about how much money somebody has when they died, sometimes they're inaccurate, So we always say, okay, let's go check if you have access to it. Let's go check your dad's last tax return. If he had all those investments, they would have produced some dividends or some interest, and all those places where he held all that stock. There'll be an account, and it would have been listed on his last income tax return, and they get the income tax return and there's nothing there. So anyway, rather than have to guess at what somebody owns, better that the trust maker or the person who's getting their legal affairs in order store all of that information. Yes, we still have a lot of clients around the country who have the old paper files or the when I die folder, and everything's in pen or pencil. That's okay. But feel free to use technology if you can to store things. So if you're a successor trustee, now you've reviewed the trust instrument to determine the trustee provisions, including who is the trustee, what are trustee rights, what are trustee duties. You've looked at the beneficiary provisions, who's going to inherit. You've realized the power of attorney isn't effective anymore. Now you're in the asset accumulation, asset information stage. Sometimes looking at their tax returns helps. And I'd say at this point, you're ready to determine whether a probate is necessary. When Fred set up his living trust, in an ideal situation, there's no probate necessary, because yes, Fred will have beneficiaries designated on his IRAs, on his life insurance. He'll have assets that are no longer in Fred's name. They're now titled in the name of Fred Flintstone as trustee of the Fred Flintstone Trust, is the way Fred did it. His house, his brokerage accounts, his computer share stock, his LLCs all got retitled. And so in an ideal situation, there's no assets remaining in Fred's name that are frozen, that require Barney, the successor trustee of Fred's trust and the executor of Fred's pour over will. There's no assets that are in Fred's name that require Fred to hire lawyers to go through the probate to get those assets that were in Fred's name when he died poured over or transferred into Fred's trust. So in an ideal situation, Barney looks at things, sees how everything's titled, and says, great, I'm not locked out of anything. I'm the successor trustee. I can go deal with these bank accounts, these brokerage accounts. I can sell Fred's home. It's in the trust. I think I'll put a for sale sign in the yard tomorrow. And there's no need for a probate, but you do have to determine whether that probate is necessary. I will say, if a probate is necessary because Fred died for whatever reason, with assets still in his name, either when Fred created his trust, he didn't transfer certain assets to his trust, or after Fred created his trust, he went out and opened new brokerage account in his name when he should have opened it in the name of his trust. He formed a business in his name, which he should have formed in the name of his trust. He bought a piece of property in his name, which he should have bought in the name of Fred as trustee of the Fred Flintstone Living Trust. Now a probate is going to be necessary to take those assets that are in Fred's name and transfer them to the trust. We always want to accomplish the goal of avoiding probate, but when someone does have a living trust, and when someone creates a living trust, virtually every time they also create a will, and the slang term of it is a pour-over will. What it is it a will? It's a will that says if I own anything in my name when I die, I want it poured over into my trust, so that Barney, as the successor trustee, can disperse the assets to the trust beneficiaries. Because all of the Fred, when I die, here's who handles things and here who gets everything, all of that language is in Fred's trust. But the good news, if there's good news with a probate, is that when Fred signed his pour-over will, Fred named Barney as both the successor trustee of Fred's living trust, and Fred named Barney as the executor of Fred's will. So now that Barney has discovered there needs to be a probate because there were assets in Fred's name when he died, the probate only involves one person, Barney, because all of the heirs are part of the probate proceeding. But in this set of circumstance, Fred, as the executor of the will, is in charge of kind of managing the probate. And his job is to see to it that everything gets transferred, not to all of the beneficiaries of Fred's trust, but what the probate does is it transfers things from Fred's name, Barney's the executor, to Fred's trust, Barney's the trustee. So really, Barney's the only participant in the probate, which transfers things from Fred's estate to Fred's trust. And then once the probate is complete and all the assets have been poured over into Fred's trust, now Barney, without court supervision, without lawyers, can disperse trust assets to the appropriate trust beneficiaries. So you got sometimes when there is a trust, you've got to determine and deal with the probate situation. Next thing that I think is really important, especially from the outset, is really good communication with the trust beneficiaries. I really love the group email. I really love the group video call where everybody gets together. Barney gets all of the Fred trust beneficiaries together and says, hey, let's get on a video call. I hear there's this thing called Zoom, and we'll get on it. And Barney says, I'm going to share all the information with you, all of the accounts, all of the assets. I really want you to feel like I'm doing this the right way. So I'm going to share all the information. We're going to have a discussion about what Fred's trust says and the steps that we need to go through to get this trust settled. The beneficiaries will be overjoyed that the trustee provided that kind of open communication. And maybe even Barney says, hey, I'm the trustee of Fred's trust now. Let's get everybody on a group email. And you know what? If anybody has any questions, just hit reply all to the group, and there's no secrets here. Everybody's a part of every question, every answer makes everybody feel good. I love the big group and open communication when somebody with a trust dies between the trustee and all of those beneficiaries, because they're sitting back kind of nervous. Hey, is Barney going to do his job? What's out there? I thought Fred had this. I thought Fred had that. I called Barney and he didn't return my call. I emailed Barney and he didn't return my email. Is Barney taking some money off the top? So all that real open group communication really helps. Then you'll likely, as what Barney will likely need to do, he'll probably need to get a tax ID because number for the trust, because while Fred was alive, there was no tax ID number for the trust. All of the trust brokerage accounts, when Fred set up those trust bank brokerage accounts, did the brokerage firm need a tax ID? Sure, they did. But because people's revocable living trusts use, like Fred was able to use his own Social Security number, when the trust opened an account, because a revocable living trust uses the social security number of the person who set up the trust, because when Fred set up his revocable living trust, for the rest of his life, the trust never filed a tax return. The trust never paid any taxes. All of that trust income just flowed through to Fred's personal income tax return. But once Fred died and the trust became irrevocable, nobody can change the terms after Fred died, and Barney becomes the trustee, a tax ID number will be necessary, because it's not going to be all under Fred's social security number anymore. Once you get that, you're now you have to determine whether there are some income tax or estate tax liabilities. Let's get rid of the estate tax real quick. Fred, when he died in 2024, didn't have more than $13.61 million of assets. Yes, assets in Fred's trust are subject to the estate tax, just like they are if Fred owned assets in his name. And Fred's IRAs and 401ks, they're all counted as part of Fred's estate for federal estate tax purposes. But when you added up all of that stuff, it still didn't come up to $13.61 million. So no requirement to file any IRS Form 706. If by chance Fred did have more than $13.61 million, then it's going to be Barney's responsibility to inventory all the assets. Probably going to hire a law firm or an accounting firm to prepare the IRS Form 706 to the extent Fred's estate exceeds $13.61 million. There'll be a 40% tax that applies to that excess. But most people this year, they'll pass away. I think there might only be, in the United States, all across our great country of the United States, I think for 2024, based on the $13.61 million exemption, there's only going to be, I'm going to pull this number out of thin air, maybe 2,000 to 3,000 federal estate tax returns filed, and a lot more people than that are going to pass away. So let's just say in our case, Fred didn't have that estate tax liability, but Fred's final income tax return needs to be prepared. And so Barney needs to keep an eye on that, wants to make sure you get the old tax return so you can compare what Fred did, Fred's income in 2024 to what he did in 2023 and 2022. Another responsibility that Barney has will be paying all of Fred's bills. Maybe Fred had some credit cards, some funeral expenses, some ongoing bills, not uncommon. So it's the successor trustee's responsibility to pay those bills or pay those debts out of a trust account that Fred had and now that Barney oversees. Going to be Barney's job as the successor trustee to continue managing all of the trust assets, at least until they're dispersed out to the beneficiaries. But oftentimes assets, they don't get dispersed the day after Fred dies, because sometimes financial institutions, they need to see the death certificate before they'll authorize the release of the funds. Maybe the beneficiaries have to set up accounts at a brokerage firm so that the assets can be moved from Fred's trust account into the beneficiary's individual accounts. Maybe it's appropriate for Barney, as the successor trustee of Fred's trust, to sell Fred's home, because there was no Fred's trust, he didn't say, I want to leave my house to this person. The house was just another asset. It's appropriate for Barney as the successor trustee to sell it. So the day after Fred dies, Barney sticks the for sale sign in Fred's yard, and Barney's going to have the ability to close on that house, assuming he finds a buyer, does the purchase agreement, schedules the closing. And again, the beauty of that's all outside of the court and attorney involved probate process. So part of the responsibility of that successor trustee is to manage and in some cases sell the trust assets. Of course, if Barney does sell Fred's home, when Barney goes to the closing and signs the sale papers as the trustee of Fred's trust, Barney will get that check payable to the Fred Flintstone Trust, and he'll deposit that check in a bank account titled in the name of the Fred Flintstone Trust for ultimate disposition to the beneficiaries. Another thing, particularly if there are several beneficiaries to receive the assets when Fred dies, is Barney may want to consider having a trust settlement agreement signed by all of the parties or all of the beneficiaries to that trust, by all of the beneficiaries signing off on a trust settlement agreement. And this is outside of the courts and all that, but when that happens, the beneficiaries will agree to the interpretation of the trust, and the beneficiaries will approve the trustee's reports and accounting. So if there's any question about, how should Fred's trust be interpreted? Did he leave this amount this way and this amount this way, or could it be read so that something should go this way? Well, by all of the beneficiaries signing off on that trust settlement agreement, that really closes the door on a potential dispute later as to a trust interpretation or a question regarding a trustee's actions. So always advisable to have that trust settlement agreement. Once that's in place, then it's time for Barney now to make his distributions. So if the Fred Trust had bank accounts, Barney's going to write checks out of the Fred Flintstone Trust bank account. If there's a brokerage account with various different stocks, there's Apple stock, Microsoft, Google, Exxon, all the companies in that Fred Flintstone Trust brokerage account, probably what's going to happen is Fred's going to have the beneficiaries open their own brokerage account, probably at that same place, wherever Fred's account is. And that makes it easy for Barney to distribute. If there was 100 shares of Google stock, or whatever Google's called, I think it's called Google, and there's 4 beneficiaries, then Barney will transfer 25 shares from the Fred Flintstone Trust account. He'll transfer 25 shares into each individual beneficiary's account. Once the individual beneficiaries get their stock in their account, they can do whatever they want to. They can move it, they can sell it, they can do whatever they want to. But typically when you have a pool of investments in someone's trust when they pass away, perhaps, yes, the trustee has the authority to sell all of that. I kind of feel like it's a little bit risky when trustees do that, because what if, the day after the trustee decides to sell all of Fred Flintstone stock, the stock triples in value, and then everybody's, of course, blaming you because you sold the stock, and now the beneficiaries are only receiving 1/3 of what they should have received. So, and you want to do all those stock transfers kind of expeditiously if you can, because if Barney lingers around and doesn't transfer that stock to the beneficiaries, and while Barney is lingering around, the stock tanks, and then Barney distributes the stock to the beneficiaries, what do you think the beneficiaries are going to say? They're going to say, well, geez, Barney, if you had been on the ball, you would have transferred that stock to us earlier when the stock price was so high, and we would have sold it because we got a step up in basis, and we wouldn't have lost all this value. Barney, shame on you. We're going to hold you accountable. So anyway, that's all in line with this duty Barney has to get things done within a reasonable period of time, like any other trustee should do in a trust administration like this. I will say, though, Barney's got to really look at Fred's trust instrument, because it's going to name beneficiaries, and perhaps it could say, I leave X percent of my estate, or I leave X dollars to this individual outright. But it could also say, I leave X percent of my estate, or X number of dollars, or this particular asset to this beneficiary, but in trust. And that trust will go on for perhaps years after Fred dies. That's what I call when Fred set up his revocable living trust, within the terms of his living trust, Fred set up sub-trusts. Fred said, you know what, I'm going to leave my great nephew $100,000, but you know what, my great nephew is only 2 years old. So Fred, in his trust, says, when I pass away, I leave $100,000 to my great nephew, but it's going to be in a trust. I name Barney as the trustee. Barney can use the assets for my great nephew, for my great nephew's health, education, maintenance, and support. And then when my great nephew turns age 25, he can have whatever's left in his trust. So you have to determine whether those distributions that are provided for in a trust are payable either outright or to a subtrust. If somebody had a will and they left things in a trust, that would be called a testamentary trust because the trust terms were part of Fred's last will and testament. But here, Fred had his living trust. That was the kind of document that controlled who gets what. And so when someone leaves things to a trust from their living trust, they're leaving things to what I call a subtrust. A lot of trust lingo there. Okay, so there you have it with the single person. Get the information, get the asset information, review the trust instrument, pay the bills, find out what the debts are, take care of all those, determine the tax responsibilities, manage, or in some cases, sell trust assets from the time that Fred dies until they're dispersed to the beneficiaries. Get your trust settlement agreement, and that will keep the trustee from some later claim that a trust was misinterpreted or some accounting was incorrect. Get your trust settlement agreement signed by the beneficiaries, then distribute those trust assets to the beneficiaries, but make sure that there's no subtrusts that assets need to be distributed to, because if you're supposed to just distribute assets to a subtrust, you're really distributing the assets to the trustee of that subtrust. And so be aware of all that. Okay, now we'll move to the married couple, which really adds a little layer, or can add a little layer of complexity. When we have a single person, what usually happens, particularly if they have children, single person dies, there's a trustee named, maybe one of the adult children, maybe co-trustees, maybe somebody else. And really the job is, hey, let's pay the bills, let's get the assets dispersed, end of story. When you have a married couple and one spouse dies, you're often not dispersing anything. Things are still going to be hanging around for the rest of the surviving spouse's lifetime. So there's several issues involved in that. First, we have to look at, now we're talking about Fred and Wilma. So Fred and Wilma together, they created their living trust, and their trust says what happens when one of them dies. Then their trust says what happens when the surviving spouse dies. So you've got to look at all that. Now maybe Fred and Wilma had separate trusts. So there was the Fred Flintstone Trust, and it had assets in it. And there was the Wilma Flintstone Trust, and it had assets in it. We see separate trusts often when Fred and Wilma each have different beneficiaries who are entitled to assets when one or the surviving spouse passes away. So for example, Fred may have 3 children of his own and Wilma has 1 child of her own. Fred may want to have his own Fred Trust. And the Fred Trust might say, when I die, maybe some assets go to the children right then. But then the Fred Trust probably says, well, these assets can stay in trust and Wilma can get the income and maybe use the principal. Maybe it says that for her lifetime. But then when Wilma dies, the rest of the Fred Trust assets go directly to Fred's trust, Fred's children, and the Wilma Trust assets go to Wilma's child. So if you have different beneficiaries, it's not required, but you often see those couples each having their own trust. But I'd say the more likely scenario is when Fred and Wilma have the joint Fred and Wilma revocable living trust. Okay, so let's say they do have their joint trust. And oftentimes, especially if the trust was written many years ago, because in another live stream yesterday, I talked about how in the old days, it was kind of the thing to do when the first spouse died for estate tax planning purposes, which is not as relevant in 2024. But in the old days, when people did their trust 15 or 20 years ago, when the first spouse dies, the idea was dump as much of the first spouse's assets as possible into, I call it a credit shelter trust. Don't dare lump those assets into the surviving spouse's estate for fear that the surviving spouse may have an estate that's too large for federal estate tax purposes. Well, 13.61 million. Married couples really can exempt 27.2 million from the 40% estate tax. But nonetheless, people are dying today, and that joint trust is requiring that when the first spouse dies, that the assets of the first spouse that are in that trust get carved out and put into a separate trust. This whole arrangement may be called family trust and marital trust after the first spouse dies, may be called AB trust. What I'm going to call it is the Fred and Wilma Trust, joint trust, and all of the assets that Fred and Wilma own and all those assets that they acquired during their marriage, they're all in that Fred and Wilma Trust. And it's likely that the trust says when the first spouse dies, in our case it's Fred, then Fred's portion of the assets, let's call it Fred's half of the assets, get broken off and they get transferred to a new trust called the Fred Trust. Now, why in the world would Fred and Wilma create a joint living trust that requires that when one of them dies, when Fred dies, half of the assets get carved out into a new Fred Trust, and then the other half of the assets get carved out into a new Wilma Trust? Well, perhaps they did it for estate tax purposes, but they don't need that anymore. But that may have been why they did it. Another very likely reason they did it is Fred and Wilma both said as part of the planning process, Fred said, you know what, when I die, I don't want to just dump all of my assets so that Wilma could go in her older years, get influenced by some guy, maybe even remarry, and he might even influence her into leaving her and my assets to that next spouse. I want more protection for my children. So the Fred and Wilma Trust says when Fred dies, Fred's assets get broken off into the Fred Trust, which becomes irrevocable now when Fred died. Wilma's trust is still revocable. She can leave her part to whoever she wants to. But some joint trusts say when Fred dies, Fred's part goes into the Fred Trust. It's irrevocable. And the Fred Trust probably says Wilma can get income from the Fred Trust for her lifetime. But the Fred Trust says that when Wilma dies, the Fred Trust assets must automatically revert to Fred's children. Wilma can't change the terms of the Fred Trust after Fred dies. Wilma can only change where her part goes. I do find that a lot of surviving spouses consider this to be a hassle because, oh, geez, now I've got to maintain two trusts. And Wilma might say, yeah, I realize I'm the trustee of both trusts. I'm the trustee of my trust and I'm the trustee of Fred's trust. But do we really need two trusts? And the answer is yes, you do. So sometimes, and a potential tax downside of that is when Fred died, yeah, Fred's assets got to step up in basis, but Wilma may live another 20 years. And the Wilma trust assets, they won't get any kind of the Fred Trust assets won't get another step up in basis when Wilma dies 20 years after Fred. So if Fred dies, yep, step up in basis for Fred's assets, but Wilma might live another 20 years, and those Fred Trust assets may really appreciate in value, but they're not going to get another step up in basis when Wilma dies. So for a couple of those reasons, married couples at least need to be informed enough to know to be able to make an informed decision. Maybe they say, you know what, Fred and Wilma might say, when one of us dies, let's just keep the whole trust revocable by the surviving spouse. And that way we don't have to break it off into two new trusts. And when Fred dies, the entire trust is amendable and revocable by Wilma. That means all of the assets are going to be included in Wilma's estate. But they don't have anywhere near $27.2 million of assets. And all of the assets get a step up in basis when Wilma dies. And it's simpler for Wilma to deal with it that way. So there's a lot going into that. What happens when a married couple has a trust and one of them dies? There's a lot that goes into planning for that when Fred and Wilma are alive and well. What the decisions that they make, they have tax consequences, not just estate tax, which affects so few people, but capital gains tax, income tax, and also lots of non-tax considerations of what are the spouses and children's rights going to be when the first spouse dies. So all that becomes really important. But I will say, in probably a majority of situations out there, when the first spouse dies and they had a joint trust, it requires that joint trust be split into two new trusts. Okay, so yes, and then Still same. Is there an estate tax filing requirement? Or there income tax filing requirements? Are there bills that need to be paid? The trust administration for a married couple when one spouse dies typically isn't quite as intense as when a single person or a surviving spouse dies. Because when the first spouse dies and the couple had a joint trust, typically nobody's getting anything. The kids aren't getting anything. Yes, there may be a requirement that things be broken off into two trusts, but that's all typically under the surviving spouse's supervision and realm. So it's typically pretty calm. Nobody's waiting for their $1,000,000. Nobody's waiting for their check for $100,000. That comes when the surviving spouse dies. Okay, now when the surviving spouse dies, if things weren't done right when the first spouse dies, then there's a bunch of accounting that's necessary because Fred and Wilma may have different beneficiaries, and if they didn't break everything off when Fred died, now you're having to go back. Okay, what's Fred's assets? What's Wilma's assets? Boy, after Fred died, assets appreciated, assets depreciated, assets produced income. It can get really tricky. So that's why it's important to get things settled when the first spouse dies, so that we'll know exactly what assets are the assets of the first spouse to die and what assets are assets of the surviving spouse. This is a mouthful and I'm rolling along here, but we're going to go to the chat here in just a couple of minutes. All right. So yes. And then when that surviving spouse dies, same issues for the single person. Successor trustee might be one of the children, could be whoever, could be a trust company. They'll have to, again, manage all the bills, the debts, figure out whether assets need to be sold, make sure assets get distributed to the beneficiaries at the right amount and the right proportion. So all those things that we talked about earlier. Okay. So what I want to really summarize here, now that you're listening and you're alive and you're well. And so now that you've discovered, and maybe you already knew some of this stuff, maybe you knew all of it. Now that you know what happens when a settlor is a person who set up a trust, also called a grantor, trustor, trust maker. I'll call it settlor. Now that you know generally what happens when a settlor dies, whether that settlor is unmarried or married, you should be better equipped to address your own planning. You should now realize, look, I got to get myself organized. And I talked to a gentleman on a Zoom call about an hour and a half ago. He says, Paul, I got stock accounts all over the place. First thing I showed him was I pulled up on my Zoom call, I pulled up the online vault, and I showed him how he could document all of his accounts and all of their values in his secure vault and ultimately have everything there, which he was excited about. So you're probably starting to realize, because that trust settlement can get hairy if people don't know what's there and you have stuff all over the place, you need to get yourself organized. Of course, you may need to make the right appointments. You're starting to learn now about what that executor or trustee's roles will be in managing assets, paying bills, communicating with beneficiaries. So now hopefully you're equipped to name the right person or people to help handle those things in the future. And hopefully you learned a little bit more if you're married about how, and look, I've married couples, sometimes they don't even address it when they get this stuff in order. They're just like, yeah, when we both die, we want to go to our kids. But addressing what happens when the first spouse dies is a critical component that can save or cost lots of tax dollars, that can protect or not protect the future inheritance of the children. So hopefully as you're going through your own planning and you're making important decisions with your spouse, if you're married, making decisions for your children, whether they're minors or adults, naming trustees, you're more equipped to make those good decisions. Okay, so what I want to do now is I want to shift over to the chat. If you've got some good questions, great. If you got some comments, some experience, I always feel like, boy, if people can share experiences. Good example the other day was when I asked, hey, if you're out there and if you can share, because maybe you had a parent in a nursing home, what the monthly nursing home expense is in your city, that'll help all of us. So yeah, here people started throwing out figures. They were in New York, California, Florida, Tennessee, Georgia. And so sharing those experiences is great. Larry, how you doing? Desnados, hello, good, great to have you. Dasnodos, or whatever your name is. Jimbo, I see Jimbo from North Carolina a good bit. Good to have you here. I'll call it Das. Home is in a trust, and I want the successor trustee to give the sale proceeds to a friend. Is that going to be problematic? I want my friend to avoid capital gains tax and hassle of selling the house. Perfect scenario there. So Fred Flintstone has his house in his trust. He names Barney as the successor trustee of the Fred Flintstone Trust, but Barney wants his house to go to Bam Bam when Fred dies. So Fred dies. Barney looks at the trust. Barney sees he's the trustee. Barney sees that the house goes to Bam Bam. The moment Fred died, the basis in the house steps up to the fair market value of the house, whether Barney sells it as the trustee or whether Barney transfers the house from the trust to Bam Bam and then Bam Bam sells it. So it sounds like you would like that trustee to sell it. So don't worry about losing the step up in basis. The moment Fred died, the basis got stepped up. Barney then sells the house, check at closing, payable to trust, and then Barney deposits that check into a trust account and then disperses those funds to Bam Bam. That's the way you do that. And so it should work like a charm. Any specific actions that my successor trustee must take in order for the home sale process to begin, my friend? Just no, it just needs to have the authority to sell the house, which typically is provided in a living trust instrument. So there we go there. Austin, so glad to be here. Glad to have you, Austin. I used to think that was Australia, and now I know it's Austin. Jalen, good. Greg, question, do you work with folks from Tennessee? We have a lot of clients from Tennessee, and I don't want this live stream to be a plug on my national estate planning law firm. But yeah, in the description, you can click on a link, answer a few questions. If it's appropriate that we talk, I'll send you my calendar link. We'll be off and running. We have our co-counsel attorneys around the country. So you'd work with me and my close staff, Tennessee person. And then once we got everything prepared, we get our Tennessee co-counsel to participate, just another pair of eyes, looks over things, allows us to meet all of the requirements to help people in Tennessee. So yes, description, take off and running from there. Hey, Darlene, hey, John, Greg, unless your friend is a relative, they will have to pay more taxes than a relative would. You will have to look that your friend will not be able to avoid capital gains tax. I don't know if you're talking about maybe a state death tax, that the closer the relationship to the deceased, the less state death tax. And there's only a few states that have a death tax. I don't know, Greg, if that's what you're getting to. I'm just guessing. Austin, love the Flintstone references. Austin, now I know you're in Austin. I thought it was Australia. Now I know you're probably around my age because I'm a Flintstone, or was a Flintstone fan 40 years ago. Sophia, thank you for the opportunity to learn. Good. Mark, Google is Alpha. I knew I had dog it. I said Google, and I had a feeling there was a different name for it. Alphabet. Thanks, Mark. What's really fun is when the auto and homeowners insurance term is ending before you as executor and successor trustee finalize the distribution of assets. This is my latest problem. Good comment there, Sandy. Sometimes, you have to notify the auto insurer, the homeowners liability insurer, and say, hey, so-and-so just died. I'm the successor trustee. This house is going to continue to be in the trust until we sell it. What do we have to do to maintain the insurance? And so, yeah, that insurance, and a lot of people will come to me after Fred Flintstone dies. He had a car, wasn't a very nice car. It's one where he had to run his feet under the engine to make it go. Hence you Flintstone fans. But somebody always says, hey, Paul, Fred died yesterday, and I realize the car may not be sold for a couple of months, or I realize we may not transfer it to the beneficiary in a month or two. Can I go ahead and drive it? Right now, it's a nice car. I'd like to drive it. And I'm like, man, no, you got to get in touch with Fred's insurance company and make sure that thing's covered. Don't drive it. Larry, if only a house is in the trust and the grantor had a credit card balance, could the non-spouse successor trustee simply explain there is no money in the estate to pay that obligation and end it there? they could explain that, Larry, but if you look at the rules, if there is an asset in the trust, like a house, even if there's no money in a trust bank account, the credit card company has the right to have the credit card debt paid, even if it requires selling the house in order to get liquidity to pay the debt or the credit card bill. And I suppose if a trustee dispersed that trust or transferred that house immediately out of the trust to the beneficiary, technically you don't see them do this much because it's not worth it for the credit card company to pursue it, but they would have the right to go after and go after whoever that house was transferred to make sure Fred's credit card bill was paid. Great question, Larry. I was reading some stuff recently where maybe there is a little more kind of asset protection by having a living trust. And then when the living trust settlor dies, the trustee immediately disperses all the assets to the beneficiaries, as opposed to the Fred not having a living trust, and all those assets are in Fred's probate estate, where creditors can file claims in the estate, and there's formal procedures for all of that. But if someone has a trust, they disperse the assets to the beneficiaries. It just may make it less likely that a creditor would go after those beneficiaries to try to enforce a claim against Fred, even though they could, quote unquote, go after the beneficiaries. All right, Griffin Notary, good to see a notary here from Virginia. Fantastic. Mark, what is the dollar amount of an estate when trust should be considered? That's a good question. And I often equate that question and to show differences of, sometimes you can have this is a totally different way of thinking about it, so forgive me in advance. But when someone thinks about retiring, it's like, okay, what dollar amount of investments do I need to retire? That could be a somewhat objective standard. There is no such thing as what is the dollar amount that someone needs to form a trust versus not having a trust. It really isn't a dollar amount. So there have been some very difficult probates that and the probate estate mounted to $70,000 because you had accounts all over the place, maybe with minimal funds, very few shares of stock, old vehicles, maybe even an old house, and putting in a probate. And then the probate is a nightmare and it takes years because you have 10 heirs. That $70,000 estate was a mess and took years to go through probate. And I've seen some $4 million probates. Person died with one probate asset. It was worth $4 million, but the probate was about as easy as it gets because it was one asset going to one heir. So it's not really a how much do you need to have to form a trust. It's more of, let's look at what you have. Let's look at what it's going to be like if there's a probate, and let's look at what it's going to be like if there's a trust. And you pick which one sounds like best for you. So yes, does amount of assets, is that a factor? It's a factor. But it's not. I can't just give you an answer. If you have under X, don't do a trust. If you have X plus, do a trust. It's just not that simple. Good question though. Whiskey, Arizona. Yeah. Okay. No question. Oh, good. Glad to have you, Whiskey. Austin still listening. Larry, on my CC question, all financial assets were distributed and as beneficiaries. Okay, good. Nice and quick and easy. Griffin, let's hit the like button. Thank you, Griffin. It seems like every night somebody different suggests to the crowd that they hit the like button. I love that. And the subscribe as well. $4,200 a month for hospice care near Sacramento. Thanks. $7,500 a month for memory care in Wisconsin. Thanks. Biter Gillette, Griffin, full-time notary. Keep hearing notaries need to be certified in order to notarize. Is that really a requirement? Certified is what? I'm not sure. Good. Gerald. Hey, I actually met Gerald and it made my day. Gerald, good to have you on here. Gerald's one of my favorite all-time clients. Good. Hey, Gerald, I know you're smiling. Let's see. These videos have been great. So helpful. Fantastic. Jimbo, education is powerful. Understanding is sometimes difficult. Good. Taking a lot of notes. Good stuff here. Do your parents have a trust? Sounds like they didn't in your previous video. I'm not going to get into that too much. They didn't. They were old. And I knew if anybody could handle a probate efficiently, it would be me. I almost, I was the son and I didn't want to, they knew nothing about a trust and I didn't want to impose it on them. It's just a long story, but all of that worked out okay. But yeah, you're right. They didn't. Daniel, how does property in an irrevocable trust pay property tax? Does the amount owed get charged back to the beneficiaries once it gets divulged? The trustee was living at the property for 5 years. Thank you. Well, you're welcome. That's a tough one to answer. I would hope that if a piece of property is in an irrevocable trust, I would hope that that irrevocable trust would also have some liquid funds in order to pay the property tax, or maybe the property's income producing. Yes, is it a tough situation when the only asset in a trust is a valuable piece of property that requires perhaps significant property tax to be paid each year, and there's no liquidity or funds in the trust to pay the tax? Yeah, that seems like something I'd want to address correctly on the front end. And I have had people leave their farm property or leave something, leave land. They want it to be in a trust for many years after they pass away so the children and the grandchildren can enjoy it. And so they don't even think about, what about the property taxes? What about the cost of the insurance and the maintenance? So in those cases, not only do you leave the farm in a trust to go on for decades after you pass away, but perhaps you should leave a pool of funds that will cover those expenses for many, many years after you pass away. Austin, why don't people talk about this more? I don't know. Why is there not a checklist? There is a checklist, and so I'll have to work on getting that, making it available. Austin, good question. Pros, cons of putting your normal car in your trust. I've never heard about that until today. Insurance fine with that. What's been your experience? It is kind of a hassle for you to have to go to the motor vehicle office and get a new title. Transfer your car from Fred Flintstone to Fred Flintstone as trustee of the Fred Flintstone Trust. And in some states, they allow you, when you title your car in your name, they allow you to do some kind of, this is who gets my car when I die. Not every motor vehicle office in the country does that. There's many states that don't allow that, but a few of them do. In some states, if you have your car in your name when you pass away and you have a will that directs where your car goes, there are some motor vehicle offices that will rely on a photocopy of the will and a death certificate in order to transfer. But I will say the kind of fail-safe way to do it is to go to the motor vehicle office and retitle that vehicle. What some people do is they set up their trust and they're like, you know what, I'm not going to have my car forever. I'm just going to leave it in my name. But if and when I go buy a new car, I'll just title it in the name of my trust. Then it doesn't cost anything. You don't have to revise your trust documents. So when you acquire a new piece of property, a new vehicle, a new boat, you just acquire it in the name of your trust, and that makes it easy for your successor trustee to deal with it when you pass away. Becky says, one spouse dies, left entire estate to trust, but not the house. Should I go ahead and put the house in the trust? I am the trustee of my parents' trust. The surviving spouse will is the same. Left entire estate to trust, but not the house. So I need to ask you some more questions, Becky, and I'm kind of going fast here, so I don't know that I really understand what you're saying enough to answer that. Larry says, hit the like button. Thanks, Larry. You chose the emoji with the rosy cheeks. I have a few comments over the years about rosacea, and one doctor said I didn't have it. The last doctor said I did. He gave me some medicine. I need to take it. So I don't know if you did that with the rosy cheeks on the emoji button, Larry or LJ, as those of you are looking at it. Bobby Wagner, I'm named as executor on my parents' trust. Well, everybody says that. It's actually not the right term. You're named as the trustee on your parents' trust, the successor trustee. It's just a technicality. Dad has passed away already, and mom has a house and a few bucks in savings account. How do I proceed to sell the house after she passes? Do I need an attorney? Well, what will likely happen, Bobby Wagner, is when she passes, you as the trustee have the authority to sell the house. You don't need a lawyer. You'll do a purchase agreement with a buyer, and then the buyer's lawyer or the buyer's title examiner will research everything. And yes, you may have to supply a copy of the trust that shows you are the trustee. You don't have to have a lawyer. Again, it's the buyer who's buying the property, who wants to make sure they get clear title. That's who needs to go get the lawyer. But you'll be able to sell that immediately without legal help if you don't want legal help. All right. My dad, Austin, said, oh, gosh, I'm losing my place. All right. I'm all over the place. Oh, my dad said $1 million. I told him that's not going to happen. Chuck, reading our living trust now. Fantastic. Reading the living trust during the live stream. Fantastic. It talks about community property, but they has a specific gift of residence to the surviving grantor. Seems like a lot of lawyer talk in the trust. Probably is a lot of lawyer talk. Yeah. So anyway, there must have been some carve out trust for the surviving spouse. Checklist would be great. Griffin, there is a certification called Certified Notary Trust Delivery Agent. Not real familiar with it. Jason, thank you for all the, and to figure out, is estate planning attorneys require it? No, and that might be a state specific thing, but since I've never heard of it and I've dealt with a lot of notaries, that should probably tell you something. Thank you for all the great info, says Jason. How can you determine what the lifetime gifting amount for someone who has passed away? If it was never discussed prior to passing, does the IRS have that info? Yeah, you can go online and see what the prior estate and gift tax exemptions were or exclusion amounts. It's pretty accessible. Sandy, Bobby, make sure the house is deeded in the name of the trust now. Hi, Paul, are the funds that the grantor gives to their irrevocable trust considered income taxable to the trust? Typically, a transfer of funds to a trust isn't a taxable event. Now, once it's in the trust, if it's put in a savings account or a CD and it produces interest, then that interest can be taxable to the trust if the interest is accumulated in the trust, or it's taxable. The interest is taxable to the beneficiaries if the interest is distributed. Larry, thanks so much. Greg Wallace, thank you for your comments there. What does LOL mean? I know LOL means laugh out loud. Does it mean laugh out loud? Or does it mean something else? It doesn't really matter. Thanks, everybody, for showing up this evening. If you're live, we'll see you again tomorrow for one more. Same time, same place. See you later. Enjoyed it. Thanks, guys.